which extends refers to the legislative power. And which extends over all but three subjects of the state list.
How? There is no discussion. Why only three? What is the meaning of insofar as? Not one line, my lord, not even. My lord, Lord, before I read this, Lord, let me make one statement after reading Constitution Benjamin. The majority view, not majority, it's a concurring view, my lord, but judgment of my Lord Justice Deepak Mishra, as my lord swear, does not deal with this interpretation at all, and I'll make that good. Well, the submissions were that even majority is accepted insofar as doesn't mean anything. They have not touched upon this. My Lord, the Chief Justice of India has touched upon it. Kindly, my Lord, come to page 42, page 42. I have quoted para 316 of my Lord, the Chief Justice of India's view on insofar as. Otherwise, the majority doesn't say a word about it. And I have noted the paragraph in which para what is saying. This is not touched upon.
Where are you reading now?
Lord, page 42.
Yes, I got it.
Para 316. Lord, this is quotation from my Lord, the Chief Justice of India's view in Constitution.
Part of 71. Part of your para 71.
Para 71.
Yes, part of my para 71. But the paragraph of the judgment of CB is 316. Clause 3 of Article 239AA defines the legislative powers of the Legislative Assembly for the NCT. Subclause A empowers Legislative Assembly for the NCT to enact law with respect to any of the matters contained in the state concurrent list of the 7th schedule of the Constitution. Now, please note, this is your Lordship's finding. The ability of the Legislative Assembly is circumscribed insofar as any such matter is applicable to union territories. Learned friend may not read 3 other paragraphs without giving a context of 316. The Legislative Assembly can hence enact legislation in regard to the entries in the state and concurrent list to the extent to which they apply to a union territory. So this argument was not advanced union territories versus union territory, but your Lordships were not dealing with individual matters.
No, but there again, I've used the word a union territory. I have not said the union territory.
Yes,
the union territory would mean that...
mean all also.
No. The union territory would mean the union territory which is enacting the law. A union territory means all union territories.
Lordships are right. I am grateful, Lord. I missed that. I missed that. Your Lordships are right. Then your Lordships were very careful. But your Lordships, Lord, it never fell for your Lordship's consideration subject-wise. Your Lordships have made it very clear. All, Lord, the 3 views.
Small thing is, it might be better to read 316 from the judgment because he's only quoted part of it.
But I'll read, Lord, from the 316. Yes. Lord, it is page 4. You are right. Page 4647.
Why don't we do this? Since we are all on soft copies, can we just look at the hard copy of the judgment for a moment? Yeah. Others, or we have the judgment. We can go back and come back to this. We are on page 45 of your submissions. That's okay.
Yeah,
no problem.
It's 316.
I'll just save our marking. Where is the judgment? Just for...
Lord, it is
Volume 2.
Volume 2.
Just give us a key.
812. Sorry, volume 1, mark 59.
First one.
4829.
Convenient, volume 1.
Page?
4812, is it?
Correct.
Plus, maybe 4 pages.
Yes, you got it. मिला आपको? मुरारी भाई मिला?
Page?
ये
half
है
paragraph.
4816 देखिए.
It is over 3 pages.
4816. टाइगर मिला?
Page number.
4816.
So, number what?
There are 316.
Hima, you got it? It's 3481.
My Lord, the Chief Justice of India has converted all of us into this.
Actually, COVID converted all of us to.
Yes, yes.
That's really what gave us the opportunity.
And I am, my Lord, my learned friend also, my Lord, admitted.
No, but I'm very happy. I was noticing even Dr. Singhvi was, reading using his.
We were, both of us were, in fact, struggling with thing, my Lord, not notings with some selected pens, of which both of us are fond of. My Lord, that pleasure is.
The problem with this soft copy is that the pleasure of writing in a thick nibbed pen is lost.
That's the common.
Share with us. That's a different kind of pleasure.
That's common, my Lord, interest.
Or writing, using your own ink. I won't name the
Using
council.
thick nibbed pens with different things.
Different colors.
You can do all that with the slide.
That's true.
Possible.
Colors are available.
You just size
The
something
thick
here
nibbed pen is.
Yes, but
I won't
we can't
name-
change the thickness of the thing.
I won't name counsel, but when I was a young lawyer, we used to have senior counsel in Mumbai who used to mix their own ink.
I see.
So we had a very learned counsel who used to use use what he called burgundy.
Again.
So burgundy, he would mix the black pink. You got this ink called pink in those days. So he would mix black and red, so it became burgundy.
The delightful color because now it comes ready-made and mixed.
Now, my Lord, there are,
So many shades of burgundy.
But I said
but for example,
lecture that you are my mentor.
for example,
Mr. Mehta, I said in the lecture in the some university convocation that so far as this use of this technology is concerned, he is my mentor.
No, but
my Lord,
He
well,
taught
I
me
must
and
say,
he
I
forced
can
me.
also,
First of all, he forced me, then he taught me. Then I started.
But he has an open mind, so that it just made it easier. We used to be sitting in our own home offices at the height of the pandemic, when everything else was shut. And we would have two sets of, one desktop and a
convenient.
laptop open. So
One has to change with the time. Otherwise, you can't pace. You can't progress in the life. Life should not be static.
initially we didn't have a breakout facility. So what we did was, Brother Shah and I, we used to have a separate desktop open. So we would mute the lawyers and then talk to each other about something about the case, what to do in a small matter or a big matter, whatever. Later on, we developed the breakout facility, which made it much easier because you just had to tell the lawyers,
Correct.
could we just go into breakout for 2 minutes? And then we just go into the breakout mode and then have a conversation, which was just between the judges would be the conversation.
So the
but when
beginning.
some honorable judge, my Lord, is struggling with this, Lord, gives us a satisfaction.
Hope you fill this way.
No,
Satisfaction.
no.
But all colleagues really started, with the
Yes,
pandemic.
Lord, yesterday,
I remember just Hemant Gupta and I sat, then Brother Shah and I for a long time we sat together. Then Justice Vikram Nath, Justice Suryakant, Justice Rastogi, so many
almost
colleagues who
every. Remember
sat.
yesterday on
And of
that,
course, all of us had to get Justice Hima Kohli.
couplet with my learned friend, my Lord, on struggling of the judge, my Lord, and what is the reaction of the man. Some good couplet I shared with my learned.
No, but just like that, because COVID has so many positive aspects. One of them, the worst nightmares always have positive aspects to this. The
Yes.
power of minimalism, the power of digital work.
Power of digital media. Now, my Lord, almost all councils have conferences virtual. It saves time, money, energy, comfort, everything because 3 people coming from Bombay, etc., wasting 2-3 days, coming prior. This is that they join and this has changed the way of life for better. There's always a silver lining. Lord,
No, sir, that is the life. Otherwise, it is saying every bad thing, you have to see the good thing. Yes, you are on 316.
316. Clause 3 of Article 230AA defines the legislative power of the Legislative Assembly for the NCT. Subclause 3 empowers the Legislative Assembly for the NCT to enact law with respect to any of the matters contained in the script or concurrent list of the 7th schedule to the Constitution. The ability of the Legislative Assembly is circumscribed insofar as any such matter is applicable to union territories. The Legislative Assembly can hence enact legislation in regard to the entries in the state and concurrent list to the extent to which they apply to union territory,
To a
union territory, or of equal significance is the exception which has been carved out. Equal significance. It's not, my lord, that there are excluded entries. It's very categorical that one is implied exclusion and another is specific exclusion, namely police, public order, etc., etc.
1, 2, and 8.
So, insofar as is a separate category by itself, my lord, that's the law. My lord, my learned friend read, my lord, 462 and 463. But that, my lord, will not dilute your lordship's inherent finding, my lord, in this.
Can my learned friend read the rest?
So let's, after that, where I've quoted those entries, can we just see placitum B on the next page, just to sort of give us a little time to reflect on it, that's all.
Placitum B.
The legislative.
Yes, my lords have quoted, I skipped the quoted part.
Yes.
The Legislative Assembly is disabled from enacting laws governing the above entries, which deal with offences against the laws referable to the state list, jurisdiction of courts and fees. Insofar as they relate to public order, the police and land, this is a constitutional indication of the fact that NCT has been considered to be of specific importance from the perspective of the nation, to exclude three important areas which have a vital bearing on its status as a national capital. Apart from the exclusions, the overarching importance of a regulatory power of Parliament is underlined by the conferment upon the Parliament of legislative power over states, as well as concurrent list, subject in the 7th schedule. Unlike state legislative assemblies which wield legislative power exclusively over the state list, under the provisions of Article 246(3), the Legislative Assembly for NCT does not possess exclusive legislative competence over state list subjects. By a constitutional fiction, as if it were, Parliament has legislative power over concurrent as well as state list subjects in the 7th schedule. Subclause C of clause 3 of Article 239AA contains a provision for repugnancy. Similar to Article 254, a law enacted by the Legislative Assembly would be void to the extent of repugnancy with a law enacted by Parliament unless it has received the assent of the President. Moreover, the assent of the President would not preclude Parliament from enacting legislation in future to override or modify the law enacted by the Legislative Assembly. Hence, the provisions of Clause 2 and 3 of Article 239AA indicate that while conferring a constitutional status upon the Legislative Assembly of NCT, the Constitution has circumscribed the ambit of its legislative powers, firstly by carving out certain subjects from its competence, vesting them in Parliament, and secondly by enabling Parliament to enact law on matters falling both in the state and concurrent list. Moreover, in subjects which have been assigned to it, the legislative authority of the Assembly is not exclusive and subject to laws. That is noted on B and C. But this does not dilute the first part which says that there are two categories of exclusions. One, implied insofar as they are applicable to union territories. And second, specific exclusions, namely 3 + 3, 6 entries.
Mr. Solicitor, also now in that, since we are on my judgment, on that part, insofar as is applicable.
That's right.
Can we just here at this page again go
Yes,
to that?
I'm coming to that.
Solicitor, just show it from this only. Now we have opened this.
Yes,
that you
yes.
have-
I'll just give the page number.
4882.
460.
452, 452.
488.
No, 8 page 488.
Yes, correct.
Let's just,
Para is 460.
because then we can marry both together and have a complete
488.
perspective.
Okay.
PDF 488.
Yes.
मिल गया?
My learned friend wants to read your lordship's, my lord the Chief Justice's judgment to say that there are only 3 categories which are excluded. So, insofar as is virtually superfluous.
No, I think that Dr. Singhvi was referring to Chief Justice Deepak Mishra's judgment.
That, my lord, I'll take your lordship's not read, my lord, but
Right. Now,
para
just
by
like-
para,
just-
what it contains
just-
doesn't touch
Solicitor, let's like focus on 460.
460.
Rather,
I-
was saying just Narasimha was also saying.
In the state list and the concurrent list of the 7th schedule, there are numerous entries which use the expression
We can
state.
skip that.
These entries are illustratively catalogued below. So that I may skip the entry.
461,
461. Article, I'm sorry.
Yes.
Yes.
Article 239AA3A permits the Legislative Assembly of the NCT to legislate on matters in the state list except for entry 1, 2 and 18 and entries 64, 65 and 66 insofar as they relate to earlier entries. And on the concurrent list insofar as any such matter is applicable to union territories.
460.
In forming an understanding of these words of Article 239AA3A, it has to be noticed that since the decision in Kanya, right through to the 9th judge bench, decision in NDMC, it has been held that the expression state in Article 246 does not include a union territory. The expression insofar as any such matter is applicable to union territories cannot be construed to mean that the Legislative Assembly of NCT would have no power to legislate on any subject in the state or concurrent list merely by use of the expression state in the particular entry. This is not a correct reading of the above words of Article 239AA3A. As we see below, that is not how Parliament has construed them as well. But I'm not joining any issue. I at the outset said that yes, mere use of the expression state would not mean that the entry is excluded. It will have to be seen contextually whether on that matter, not entry, on that matter, any union territory can legislate or not. Then, my lord, 462. Section 7(5) of the GNCTD Act provides that salaries of the Speaker and Deputy Speaker of the Legislative Assembly may be fixed by the Legislative Assembly by law. Section 19 provides that members of the Legislative Assembly shall receive salaries and allowances as determined by the Legislative Assembly by law. Section 43(3) similarly provides that the salaries and allowances of ministers shall be determined by the Legislative Assembly. However, Section 24 provides that a bill for the purpose has to be reserved for the consideration of the President. Parliament would not have enacted the above provision unless legislative competence resides in the states on the above subject. The subjects pertaining to salaries and allowances of members of the legislature of the state, including Speaker and Deputy Speaker, and of the ministers for the state are governed by entry 38 and entry 40 of the state. The GNCTD Act recognizes the legislative competence of the Legislative Assembly of NCT to enact legislation on these subjects. The use of the expression state in these entries does not divest the jurisdiction of the Legislative Assembly, nor are the words Article 239AA3A exclusionary or disabling in nature. Lord, in the context of the word state,
Just read on, The purpose.
the purpose of the above narration is to indicate that the expression state is by itself not conclusive of whether a particular provision of the Constitution would apply to union territory.
Now just go slow on the next sentence. Just very slowly, just read the next sentence.
Similarly, it can also be stated that the definition of the expression state in section 358 of the General Clauses Act, which includes a union territory, will not necessarily govern all references to state in the Constitution.
So now just pause here. That is there are two things. The first part shows, the first sentence of para 463 says that merely because something, an entry says state, that will not exclude the union territory. The second sentence says, but on the other hand, merely because in section 358 of the General Clauses Act, state includes a union territory, does not mean that every reference to state in the entry will include a union territory. So both, they're excluding both extremes, you know?
Yes, my lord, your lordships have taken, my lord, the correct path, my lord. That
Now just see, if there is something which is repugnant, if there is something which is repugnant to
if
this,
there is something which is repugnant in the subject or context, the inclusive definition in section 358 will not apply. So even if state includes union territory, if the subject is alien to the union territory, it will not apply. This is made clear in the precedent emanating from this court. In certain contexts, it has been held that the expression state will not include union territories, while in other contexts, the definition in section 358 has been applied. Now, this is the finding, Your Lordship's finding. Hence, the expression insofar as any such matter is applicable to union territories is not one of exclusion, nor can it be considered to be so, irrespective of the subject or context.
Now, Mr. Solicitor, we've seen my judgment. Now, for a moment, just 2 or 3 paragraphs, let's go to Chief Justice Deepak Mishra, because mine is not the majority judgment, it's a concurring judgment. We've taken the same conclusion, but on this, Justice Mishra spoke for himself, Justice Khanvilkar,
And Justice Sikri.
and Justice
My
Sikri.
Lord Justice.
And there was a concurring opinion by Justice Ashok Bhushan also.
Yes.
Both Justice Bhushan and I spoke, right, separately.
One issue. Dissented on one issue.
Sorry,
Justice Bhushan dissented on.
one issue.
Otherwise, it's also another concurrent.
No, there is no dissent.
No, there's no dissent.
In this,
One issue, Manoj.
That's the way, although the proceedings of this court, concurring opinion, once your lordship reads Justice Bhushan's opinion on the aspect of whether union government has parallel executive power, he says it does. Whereas one of the other 4 judges, including your lordship, say, your lordships don't opine on it. My Lord Chief Justice has not opined on that aspect. And the majority, that is Justice Mishra speaking for Justice Sikri and Khanvilkar, says that there is no parallel executive power. So on that limited point, Justice Bhushan is in dissent, although the proceedings say that both the opinions are concurrent.
No. I will show, Manoj. That is
Now,
a very
just 1 second,
accurate-
just to bring focus. Now, we've seen my aspect. I will refer to insofar as is applicable. Now, according to you, Chief Justice Deepak Mishra does not deal with insofar as is applicable. Now, just let's see the conclusions of, before conclusions, para 224 and 245 of Chief Justice Deepak Mishra's judgment. If you can just, any of the juniors in the matter can give us the page, that's all.
For that, Manoj, just for my.
So there's something in my mind. Actually, we are stretching your argument. Solicitor, we are trying to stretch your argument. That's why we are telling you something which may help you.
7, the PDF page.
4773.
4773.
If I may assist, para 39 of the majority, read with paras 2 to 4
I'm going to read everything, Doctor.
on this issue. This narrow issue.
So whenever Dr. Sikri intervenes, I get the satisfaction that I'm on the correct line. Because he would not disrupt his opponent when he is committing a mistake. Your Lordships, are on page para 222. 224. I'll read 222.
239.
So that is PDF page
PDF is 4.
4777.
Where does Chief Justice Deepak Mishra deal with the legislative power?
Yes. Starting with 217. Therefore, I wanted your Lordship to see on some of the paragraphs and with profound respect say that the conclusions may not be read in isolation because there is no discussion with regard to some of the conclusions. It may not as politely as possible. There is no discussion with profound respect. Lord, may I read 224 minutes? Or your Lordships are...
Yes. (224).
224. I'll read with my Lord's permission. Article 239 AA4 confers executive powers on the government of NCT of Delhi, whereas the executive power of the Union stems from Article 73 and is coextensive with Parliament's legislative power. Further, the idea of pragmatic federalism and collaborative federalism will fall to the ground if we are to say that the Union has overriding executive power in respect of matters for which Delhi Legislative Assembly has legislative powers. Thus, it can be very well said that the executive power of the Union in respect of NCT of Delhi is confined to 3 matters in the state list for which the legislative power of the Delhi Legislative Assembly has been excluded under 239AA3A. The fourth in category, these are the only three exclusions. And such an interpretation would thwart any attempt on part of the union government to seize all control and allow the concept of pragmatic federalism and federal balance to prevail by giving NCT of Delhi some degree of required independence in its functioning, subject to limitations imposed by the Constitution. Lord, with profound respect, I have two serious constitutional objections to this. Lord, principally, fundamentally, and conceptually, union territory is an extension of the union, and there cannot be a question of federalism between union and its limb. Federalism is a concept between union and federating states. Be that as it may, Lord, there is nothing to suggest that why the majority excluded only 3 entries without even touching, insofar as it relates to union territories, no discussion on that. Merely saying that the union may seize the control, my lord, it's not a question of control, it's a question of interpreting Constitution of India. Whatever power is conferred by...
On the legislative power, now go to 284.14.
Yes.
284.14 at PDF page 4798 for all of you.
47.
That's the conclusion.
Yes, that's the conclusion without any discussion. And I'll not... I'll make that good, my lord. Kindly note that, bear that in mind. This is the conclusion, but there is no discussion why this conclusion is reached. And I will take your lordships to para by para without reading it, that what this para contains. No insofar as discussion. The interpretative process, this dissection of Article 239AA3A reveals that Parliament has the power to make laws of the national capital territory of Delhi with respect to any matters enumerated in the state list and the concurrent list. At the same time, the Legislative Assembly of Delhi also has the power to make laws over all those subjects which appear in the concurrent list and all but 3 excluded subjects in the state list. No discussion on insofar.
This, according to, doesn't factor in insofar as is applicable at all.
Is not called upon.
Not called upon to decide.
That's the reason. That you can find.
Leave it, my lord, for the reasons your lordship know, my lord, going beyond this. But when the majority holds and records a finding that exclusion is only 3 entities, whether called upon or not, insofar as will have to be taken into account.
Now, just one more question, Solicitor. This conclusion in 284.14, where is the substantive discussion on that in the judgment? Anything specifically that everything...
Let me, my lord, take your lordship.
237.
37.
Only a minute, I'll answer it.
237. Mr. Mehta, please turn to paragraph 237. There is some discussion.
Tiger, what?
Paragraph.
PDF page kya hai, Tiger?
Smile.
478.
478.
Because it is anyone and other, everyone it is considered.
Any matter.
Any matter.
230.
There is no.
No. There, my lord says
There is that reference of...
difference in any matter cannot be every matter. We have not only, I have read it fully.
Where does the majority refer to? Sorry, I'm interrupting you. Where does the majority refer to clause 3 of Article 239AA?
Analogy while interpreting the provisions of Article 39AA3A and Article 239AA4 would reveal that executive power of the government of NCT of Delhi is coterminous with the legislative power of the Delhi Legislative Assembly, which is envisaged in Article 239AA3 and which extends...
And which extends refers to the legislative power. and which extends over all but three subjects in the state list.
How, there is no discussion, why only three? What is the meaning of insofar as? Not one line, my lord, not even. My lord, we